Afternoon, everybody. Welcome to the Samfiru Tumarkin live employment law show. We're live Q&A on Facebook, YouTube, LinkedIn, and Twitter. My name is Chen, and I'm an employment lawyer at our firm's Vancouver office. We have offices across the country in Vancouver, Toronto, Calgary, and Ottawa as well. I am here live for the next half an hour or so, and I'll be answering your questions, any and all questions to do with employment law or disability law. If you're having issues in the workplace, if you're having issues with your long-term disability benefits, anything to do with harassment, discrimination. A popular topic these days is severance pay. I'm sure everybody's heard of the recession, the upcoming recession, or it might be in a recession now. But lots of mass layoffs. Obviously, severance pay is a huge issue when that happens. So I can't see or hear anybody, but if you type your questions into the text box in front of you, I'll have it here in front of me, and I'll do my best to answer. So obviously these days I'm dealing more with mass layoffs. Unfortunately, I think there was a bunch of them late last year with the tech companies. I've recently read that I think Zoom is also doing a pretty big layoff. I think over 1,000 employees are being let go. I'm not sure how many Canadians will be affected, but obviously the company grew really quickly during the pandemic, and now they're kind of having to cut back. The issue with mass layoffs is well, first of all, it's going to result usually, almost always, in more severance pay for people that are part of a mass layoff. In BC, that threshold, if more than 50 people are let go from one location, there's additional severance pay obligations. I'm sure a lot of my regular viewers are aware of the concept of what's called common law reasonable notice. There's the minimums under the employment standards legislation. So in BC, we have the Employment Standards Act, which basically says you get a week of severance per year of service, right? Up to a maximum of 8 weeks. What my regular viewers probably know is that there's usually more that the employer has to offer you. And that's called common law reasonable notice, which means that this, your age, your position, your length of service, how the job market is looking like, all of those factors get taken into account. And with common law notice, which is above the minimums under the Employment Standards Act, sometimes they're as much as 26. I've seen one case recently where a guy was let go from IBM after I think 38 years. This individual got 27 months of severance pay because the court found he was with IBM for like his entire career. He was in his 60s when he was fired. He was pretty senior. He was a manager. He was in a very specialized field at IBM, and I think 27 months is the highest I've heard. But this individual, obviously, he was terminated during COVID as well. And the important thing to keep in mind for that is the court noted that he was, the job market wasn't doing well. So I guess similar to now, in a lot of industries, we had a semi good job market in the last year, I would say, but now that we're kind of looking at this recession, that's a factor that judges have taken into account to increase in employee severance pay. So we got our first question. So for anybody just tuning in, please feel free to put in your questions into the text box. I'm here for until 1:30 or so. So let's get started with the first one. So we've got a question here from Sarah. Sarah's asking, can you be forced to take on more work due to recent cuts? We're understaffed, and I'm not being compensated for taking on more responsibilities. So I guess the short answer to your question is no. Um, if well, I guess I see a few issues in this situation. Um, if you're working overtime, right, or if you're working more than 8 hours a day, more than your normally scheduled hours, your employer should be paying you for that, right? Just because you're a salaried employee in BC doesn't mean you get, or it doesn't mean you don't get overtime. Okay. So if your employer is making you do all this extra work, just because you're on salary, doesn't mean you don't get paid for that extra time. Especially if there's something objective, like a task that's been, something objective, like you have to do task X, which you never had to do before, right? That's clearly adding to your job. Employers are allowed to do that within reason, right? But if they're taking other people's work and giving it to you and not paying you more, that's not allowed, right? They have to pay you for that. There's actually been cases in the past where um, employers have made the company's made an employee do a ton of extra work, over and above their job description. They've paid them for that extra work, right? So that's not the issue. They're paying them for the hours. But the courts have found that that has been such a substantial change to what you first agreed upon as your terms of employment, that that was something that's considered what's called a constructive dismissal, right? So a constructive dismissal is essentially whenever there's been a significant change to the original terms of your employment. So that could be a demotion, right? That could be a pay cut. That could even be, subjecting you to a toxic workplace, right? And so what that essentially means is they haven't the employer hasn't said they're letting you go, but through their conduct, through their actions, they're basically terminating your employment. And there's certainly been at least one case I can think of in the past where if the company is overloading you with work, if they're kind of just giving you, increasing your workday from 8 hours to 12 hours a day, right? Despite the fact that they might be paying you for it, that could still be considered a constructive dismissal, meaning you can say to the employer, no, you have to cut back, or I'm going to treat this extra workload as a termination of my employment, right? Because it is, getting all this, basically taking on another role. And I've talked to, a person recently where they essentially eliminated a line of management and they've just combined those responsibilities with, they've given those managerial responsibilities to another manager. So they've essentially doubled this manager's role, and doubled his responsibilities, right? Despite the fact that he may be compensated for that, right? The company's paying him extra, whatever, $10,000, $20,000, $30,000 a year. That's a huge change to your employment, and you don't necessarily have to accept that. And I hope, if you know anybody dealing with a similar situation, obviously it's they can accept it, right? If it's more work, more money, that's fine, but they're not legally obligated to. And it does depend on the circumstances, so I'll just put that out there. But it's a matter of degree. Okay, we got more questions here. We got a question from JX2. If you work part-time with multiple employers, does each employer have to allow for up to 5 sick days? If you work split shifts, do the cancellation of both shifts due to being sick then take up 2 of your sick days in BC? So JX2, I think for the first question, um, if you're working with different employers, I assume, right? If you're not working with kind of just this conglomerate, but they're completely separate employers, then yes, you'll have the sick days for each employer that's mandated by the BC Employment Standards Act. And I think you noted you're in BC. So that shouldn't, the fact that you're part-time shouldn't affect it. If you're working split shifts, does the cancellation of both shifts due to being sick then take up 2 of your sick days? I don't I don't know the answer to that question off the top of my head here. I'd have to think about that for some more, but email me. My email, go to help@employmentlawyer.ca. I just don't want to give you the wrong answer right now, Jay, but I'm sure it's um, a quick task to find it. But I don't know that answer sitting here. Um, and sorry, JX, so you can feel free to follow up on your questions to clarify. But with the split shifts, I'm not sure sitting here. Got a question here from Taylor. How binding are non-compete clauses? I was recently let go from a somewhat specialized field. You're worried that this is going to cause problems in your job search. Okay, so I mean, Taylor, I guess you've probably heard that at least in one province in Canada, in Ontario, they've kind of legislated away non-competition clauses, except for say very few select jobs, and I think those are probably the like the CEOs or the CFOs. In BC, we don't have that legislation, so I've the issue of non-competition clauses. It's a big topic, and there's a lot of nuances in it, but I'll try to give you some answers in general. Um, it there's a few factors a court will look at, right, in non-competition clauses, like how wide is the clause, right? What geographical area does it cover? How long is the non-competition for, right? A non-competition clause for 99 years is not going to be enforced. A clause that only goes for 6 months is obviously much more likely to be enforced by a court. So I would say in general, courts are very hesitant to enforce these non-competes because it's a restraint of trade, right? It puts these restraints on our economy. It puts restraints on employees, right? That if you're in a specialized field, there's only a few competitors. Obviously, if they're saying you can't work for competitors in BC, that's a huge limitation on your ability to make your livelihood. So I've seen non-competition clauses for dentists. I've seen them for lawyers. I've seen them enforced. I've seen them non-enforced. But I will say the ones that are enforced are very limited in geographical scope, right? So, for example, if you're from, I don't know, Gibson's, right? It'll just say you can't compete with us in Gibson's for 3 months, right? That's much more likely to be enforced than if the clause says you can't work for any competitors for 5 years in all of BC, right? And so I think it's the most important thing I can tell you, Taylor, is if you're concerned about it, go talk to a lawyer about it, right? Like get the contract reviewed, get the clause reviewed, and see what the lawyer has to say. Because I can tell you, there's no generic answer. It depends on the circumstances. It's different for employees than if you're a buyer of a business, right? And it depends on if it's called consideration, or if consideration was provided. Did the employer pay you something or give you something of value in exchange for you signing this non-competition clause? So I guess I'll say it's a huge topic. And one of the concerns with non-competition clauses is, and I've seen this before, is companies that know their non-competition clauses are not enforceable, right? So their lawyers telling them this is not enforceable, right? But they might come after you for it anyway sometimes, because they know that the the ordeal of having to deal with litigation, right, or the threat of litigation, is enough to sometimes you know incentivize the employee not to compete or not to go to any competitors. So that's kind of more. That's not so much about the if a clause is binding. It's more about kind of strategy and tactic in litigation, right? The practical realities of this. So I would say to anybody that's dealing with a non-competition clause, if they want to go to a competitor, talk to an employment lawyer about it. If you're in BC, come talk to me about it. Obviously, there's ways to work around them, or there's strategies that an employee can do. Well, first of all, I guess I'll tell you if it's binding or not, and second of all, we can work around what you can do to kind of to kind of make sure that you don't get sued. So Taylor, feel free to, and for anybody out there, please feel free to follow up on your questions if I wasn't clear about something. Okay, we've got more questions in the text box here. Got a question from Peter. He had a coworker that was illegally fired because of being under the influence of a substance. That wasn't actually the case. He has yet to get a termination letter for why he was let go. How could they go about the firing and to either get a return to work or severance? This is in Ontario. Yes, Peter, that's a good question. I guess I'll start off by saying I've seen some terminations that just don't make any sense to me, right? And whether it's a mistake by the company, a mistake by their lawyer, or whoever, I've seen some terminations that just the employer will say the employee did something wrong, and they have absolutely no evidence to back it up, right? So, and Peter, I think if or your coworkers should know that just because the company's making allegations, obviously they need to have the evidence to back it up, right? So that's the first thing is they're saying the coworker was under the influence of a substance. Well, they have to prove it, right? If he hasn't gotten a termination letter as to why he was let go, the termination letter, I've seen some very brief ones, right? I've seen ones that are like 2 lines, and they usually the employer or employers in Canada, I'll say this, they don't have to give you a reason, right? If you're not in a union, and I assume your friend's not in a union, if he is, let me know. But if you're not in a union, which is the vast majority of Canadians, the employer doesn't have to tell you why they're letting you go. They have to tell you, if the termination is with cause or without cause, right? Without cause termination means they have to pay you severance. It means that it's due to restructuring, downsizing, whatever, elimination of your position. Nothing to do, they're not saying you did anything wrong to warrant the termination. With cause means that, you did something wrong at work. So in this case, they're saying you're under the influence of something, or you stole some money, you punched someone at work, or some sort of violence at work. Something you did wrong caused the employer to terminate you. So that's what it sounds like in this case. Again, they don't necessarily have to give you a reason. They can just say you're let go for cause, right? And the termination letter, it's nice to have a reason in there. But if they verbally told him that he was let go for cause, and that it was because of, under the influence of a substance, that's technically, there's nothing the employer is doing that's illegal. What they're doing that's, in my view, it sounds like it could be illegal, is making these allegations without evidence and firing your coworker without proving their case, right? And so hundreds of these cases, what I call just cause cases, have gone to court, right? And the judge is the ultimate decider of whether something happened or not, and whether that the employer had cause to terminate this employee. And so in terms of how let's talk about returns to work and severance. In Ontario, unless there's no automatic right to reinstatement to your job if you're not unionized, right? Union employees do, right? Non-unionized employees, if you go to a judge, they don't actually have the power to return you back to work. The Human Rights Tribunal does in Ontario. If you can prove discrimination, right, on the basis of one of the enumerated grounds, there is a chance they will order reinstatement. As far as severance pay goes, there's generally I'll say there's 2 ways to try to get that severance pay, right? You could hire a lawyer, and send a demand letter and say that the company's got it all wrong, right? And there was no misconduct, and so you have to pay my client's severance pay, right? Which it could be a month, could be 27 months. There's a huge range, as I was alluding to earlier. The second way you can go is just by starting a lawsuit against the company, right? And in a court of law, obviously you have to have evidence of this, using the substance. at work. And so if the company has nothing, you're probably going to win your case, right? And so those are the general two ways to get severance pay. In terms of a return to work, it's tougher if you're not in a union, right? You've got to prove discrimination. And certainly I've seen cases where if you have a drug problem, alcohol addiction problem, that's considered a mental disability under human rights law, right? And so the employer can't just fire somebody because they're addicted to drugs or addicted to alcohol or whatever, right? They have to try to accommodate them, maybe put them through rehab and then try returning them to work. And so I mean, if that's something that sounds like the case, there could be a path to return to work for your colleague, or ex-colleague, I should say. So Peter, hopefully that gave you kind of a broad, or I know it's a pretty generic answer, but hopefully that helped. So follow up from JX2: as a gig worker, setting something up in the morning and taking down at night, I'll be booked for 2 shifts on the same day. I mean, I think, Jay, there's no question if you have the sick days, you'll get paid for those 6 shifts. I assume this is the same employer, right? You'll get paid for those shifts if you use your sick days. I'm actually not sure if that counts as 2 sick days or 1. I think that's the question, and I just don't know the answer to that sitting here. So we got follow up from Peter. They also allowed the individual to continue work that day and for a week and a half after this alleged incident. Peter, that's an important point, and something something that a judge would consider. That I think that would be a very important consideration, because going back to this issue of just cause, right? Courts have used the word, if it's just cause, it's impossible to continue the employment, right? Like there's a fundamental breach of trust. We can't. It's not possible to continue this employee's employment anymore. And so, in this case, it sounds like if they let this guy, or I'm saying guy, it could be a woman, if they let this individual continue work that day after they thought he was under the influence, and then they continue letting him back for a week and a half, they're going to have to explain why they did that, right? If it's allegedly just cause, because there's another principle of law called condonation, right? If you do something wrong at work and the company knows about it and they do nothing about it for months, or even in this case, a week and a half, and then all of a sudden, like a year later, they decide to terminate you because you did something wrong at work a year ago, the employer is prohibited, right? They can't do that. And the reason is they have an obligation to kind of, if they think something is wrong at work, they've got to discipline you right away or warn you about it right away. Or in this case, if they thought it was just cause and this coworker was under the influence, they should have, terminated immediately on the same day. The fact that they let this individual back to work goes against their own case if they're alleging just cause. So yeah, Peter, thanks for raising it. I think that's a key point, or a key consideration here in this case. Okay, so we've got a few more questions here. Follow up from JX2: would a long-term enforceable non-compete then extend to the severance obligation to the term of the clause rather than the 2-year limit set by the common law? Good question, Jay. So no. Well, I guess the short answer is no. The courts don't usually tie the length of the non-compete to the length of the severance period. I mean, obviously, to me, that only seems fair if you're asking someone not to compete against you for 2 years to the point where you can't even work. And if you're a lawyer, if you're a dentist and you can't work in Vancouver, right? It makes sense to me if they fire you, they should pay you out for the length of the non-compete. Unfortunately, I don't often see that. I've certainly seen cases where the employers offered severance pay to cover the length of the non-competition clause. I've seen that, but that doesn't necessarily mean that the employer has a legal obligation to always do that, right? So I've seen non-competes for a year, and I've seen the severance last, let's say, 6 months, right? And so you have that 6 month period where you're not getting severance and where you're still covered by the non-compete. I think that, in those, you got to address that at the beginning, right? So before you ever come to that scenario, you got to address it at the beginning. And by the beginning, I mean when you're first hired, right? If you get presented with this 20-page contract, I would get it reviewed by a lawyer, right? Especially if it's, a lot of language that sounds it's giving the employer a lot of rights. You have to it's the best way to deal with it is address it at the beginning and say, okay, well, it says here you can let me go with 8 weeks severance, but you're asking me for a non-compete for 2 years, right? And so you've got to point that out and get that fixed at the beginning. If you don't, I mean, there's still ways around it. And like I said before, in general, non-competes are, they tend to get struck down in BC, right? But the issue is you've got to kind of deal with this. If the employer actually tries to enforce it, you've got to deal with the litigation, right? And it's just obvious. Nobody, I shouldn't say nobody. Most people don't want to deal with that. So I think it's important to kind of deal with that at the beginning. But if you have to deal with it at the end, go see a lawyer and they can help you navigate through it. If you're in BC, come see me. There's some certain strategies and tactics you can try to negotiate away the non-competition, right? So so for example, as part of severance negotiations, one of the terms of the agreement could be, the employer, the company waives that non-compete. So hopefully that helped. So we got one more question here from Julian. So Julian's asking, can you be brought back to a different position after taking sick leave? You were off for a couple months, but now they're saying your position does not exist anymore. This new job is lower pay. So yeah, Julian, there's that question raises a few different issues. I think first and foremost, I mean, hopefully most of you guys are aware, but under human rights legislation in Canada, you have a protected sick leave, right? Well, I guess employment standards and human rights legislation. So if you need medical leave, your employer has to kind of accommodate you in that process. If you need to be off for a few months or a year, the company has an obligation to accommodate you. When it's time to come back, that's when it gets more complicated, right? I've dealt with at least one or two cases recently where this was an issue. So I think the company doesn't necessarily have to return you to your same position, particularly if they can prove that there was a bunch of restructuring while you were gone, right? I remember a case back from the late 2000s, I think, involving I think it was Van West College, but it was a very similar case where a woman went off on maternity leave, and when she came back, they had restructured and her position was gone. That didn't prove to be a defense to the discrimination claim that was ultimately brought against the college. And the reason is because the tribunal will tend to look at if you hadn't gone off on this leave, so disability leave or medical leave, would you still be employed by the company, right? Did that leave somehow negatively affect your employment with the company? So I think that's kind of the key question. In that case, they found that if this woman had not gone off on maternity leave, she'd be in a maybe not her same position, she'd be in a different position right now. And because she was an excellent employee, her performance was excellent. So the tribunal made that finding that just because her position was gone, her old position was gone, doesn't mean that the employer wasn't under an obligation to offer a new one. So all that's to say that if you accept the premise that your position doesn't exist anymore, right? The company still has an obligation to find you something else, right? And they don't have to create a job for you, but they have to kind of look at these other jobs that are available and see if that will fit you, right? A comparable job. Now, the last part of your question about the lower pay. So this is where it gets tricky because it's really a matter of degree. Um, if the company can prove that this is the best they can do, they've made best efforts to try to accommodate you and put you into this position that's you know 5% pay lower than before. um, that's different than give them cutting your pay by 50%, right? It's a matter of degree. um, and it's a matter of why they did what they did and how they came to that decision, right? If they did not consider the fact that if the medical leave that you were on was a part of their decision to demote you into a lower paying position, that's discrimination, right? And that's a human rights complaint. um, if your new lower job is, I'd say, anything more than 10 or 15% than your old job, if the pay is lower by that much, put the human rights claim aside, there's a constructive dismissal claim there, right? And this is what I was talking about earlier in the session. If they make a huge change, if the employer makes a huge change to your job, you don't have to accept that. You can claim for severance pay. So hopefully that answered your question, Julian. Hopefully I didn't miss any questions today. My colleague Samara from Ontario is on tomorrow if I've missed anything. So for all you Ontario folks, be sure to tune in tomorrow if I've missed anything. I'll be back in 2 weeks. But thanks everybody for coming out. And I'll see you guys in 2 weeks.